Welcome to Court RENOvations, a podcast about reshaping our courts to better serve families and communities, brought to you by the National Council of Juvenile and Family Court Judges. I'm Joey Orduña Hastings, your CEO of the NCJ-FCJ. Founded in 1937, the NCJ-FCJ is the oldest judicial, membership, and education nonprofit in the United States, proudly headquartered here in Reno, Nevada. Reno isn't just our home. It's where bold ideas take root and transformative change begins. In each episode, we'll hear from people driving these efforts, judges, attorneys, court professionals, and change makers, as we explore how courts are reimagining justice. So let's dive in. Court RENOvations starts now.
Welcome to the Model Court Movement, a podcast series exploring 3 decades of innovation in child welfare courts. We're your co-hosts, Zoe Livingood and Mariah Taylor. And in this first episode, Pioneering Justice, we're taking you back to the beginning to explore how a few judges making important changes in their courtrooms grew into a national movement that transformed the child welfare system. Today, we're joined by 4 incredible guests who were there in the early days of the movement. First, we're joined by Judge Sharon McCully, who served as a judge in Salt Lake, Utah, and played a key role in creating standards for child abuse and neglect case processes. We are also joined by Judge Gray, who served the Orleans Parish in Louisiana with distinction for over 35 years. A champion for children and families, Judge Gray led one of the nation's first model courts, setting a standard for innovative, child-centered judicial practices. Next is Judge Rubin, whose court was among the early adopters of the model court approach in the country. And finally, Dr. Sophia Gatowski, who served as an NCJ-FCJ site liaison to the model courts and has conducted studies of court practices across the U.S. to inform policy and practice change. Thank you all so much for joining us. I would like to hear, to get us started, I would love to hear from each of you about how you got started into this model court work. And I'd like to start with Judge McCully.
Well, I got started because I was a member of the drafting committee that produced the original resource guidelines for best practice in child welfare proceedings. We started in 1992 through 3 years of many meetings and agonized drafting. We released the resource guidelines in 1995. We knew we needed to be able to demonstrate to other courts, other judges, that this really could be done. I spent much of the first 3 years saying this can't be done. And then I became converted. And so we came up with the idea that we needed more than one court or even 2. We started with Cincinnati and Grand Rapids before that. But we needed courts to be able to demonstrate implementation of these new guidelines. And so we came up with the idea of a few courts going through the process of making major changes in the way we handle child welfare cases. And Utah, I think, was first after Cincinnati. Cincinnati is really where we all started and got most of our first training. But Judge Grossman on that court kind of led the way, and he was also the chair of the Resource Guidelines Committee. So we began adding other courts. Salt Lake had a head start, and I'll tell you about that later. But that's how I became involved.
Thank you. How about you, Judge Rubin?
I became involved with the National Council because I was in a court system that was very severely broken in our county. Nothing ever happened. Cases were passed judge to judge with no scheduled second hearings or any kind of reasonable time frame to have hearings. And I had become a juvenile court judge. And I, of course, first thing that happened when I went to Reno for juvenile judge school was I met Tom Hornsby, and he took me under his wing and he said, "You're in. You need to join. You need to immediately have you join. I'm going to have." He was the president at the time. "I'm going to have you come to a meeting, a board meeting, so you know what's going on, and you're going to be on the board before you know it." And that's what happened. I was so interested in making changes to the system. It was just horrific what was really happening, frankly. So we came to a meeting. The presiding judge of the juvenile court, Annette Warner, said to me, "You're on this board. You want to be on this board." Of course, I didn't get on when she advocated for me, but she came back from Big Sky, and she said to me, we should do this." That's where she learned about it. I hadn't known about it. She said, "We should do this." And so we moved in to become one of the early group of model courts. That's how I got into this.
Great, thank you. It's great.
It's interesting. All of our stories seem to be similar in a couple of ways. I was elected in Orleans in 1984, joined the council immediately in November of 84, and joined the council in 85. And the person that I ran into first, who talked to me about the importance of joining the National Council of Juvenile and Family Court Judges, was Judge Romay Powell out of Atlanta, who was the president. And I also had back in my hometown, Judge Muley, Salvatore Muley, who had been a member for a long time of the council, who said, they both said, "You have to join and you have to be active." And so taking them up as people who knew what I didn't know and had some trust in their recommendations, I did become active in the council. Like Steve, Tom Hornsby got a hold of me and said, "This is what you got to do." Lots of people, Judge Grossman, they all talked about the importance of the work. And at the time, we were just in Orleans. We were coming out of a situation similar to what Steve talked about. We had been dubbed the worst court in the nation by the New York Times. And so I didn't like that title. I wanted some other title for our court. And I saw the model court as an opportunity to perhaps address some of the things that we were, when we were made aware of in Orleans, that we needed to do to make the system better. And so I believe that the model court movement was something that would help me do that. And so I latched on to Sharon and Steve Rubin and all the other people around, and Sophie, and tried to learn as much as I could about the movement and to bring things back to New Orleans that would help us improve the court.
That's awesome. Thank you. And last but not least, Dr. Gatowski.
Well, I came to the Model Court Project in the mid-90s. So I had just completed my PhD in social psychology with a specialization in social psychology and the law. My dissertation had been an examination of judicial decision-making. So I was looking for a nice little postdoc position where I could get some more experience in the field, have access to judges, continue my interest in studying judging. And a position came available as a research assistant with the Permanency Planning for Children Department of the National Council of Juvenile and Family Court Judges. So PPCD, as we called it, was the former title of what is now the Child Welfare Program at the National Council. So I began as a research assistant, and I was planning to get that experience that I was looking for and then move to an academic position. I had always aspired to be a professor at some university somewhere. But then the Model Courts Project launched. And I was given an opportunity to stay in a position as a senior program manager and a model court liaison. And that opportunity was just way too good to pass up, because it was giving me the opportunity to work in the trenches with courts and judges as they were working on collaborative systems reform, unlike any other experience that I could imagine, and way more rewarding and fulfilling than an academic position, in my opinion. So that short little postdoctoral stint that I imagined for myself turned into a more than 15-year career with the National Council, working with the model courts and its other iterations, and model courts next generation and the implementation site. So that opportunity to help out, bring my research lens to court practice was what led me to stay, and it turned out to be absolutely the right decision for me.
Awesome. Thank you so much. We really have so much expertise in this Zoom room with us today. It's hard to get down to that in the next hour or so, but I just, thank you so much, everyone here. We're going to hear so much great stuff upcoming, and I'm really excited to hear more about, the beginning of what has become such a momentous movement. With that, we're going to move into our first discussion with Mariah.
Okay. Hi, everyone. My voice is a little not here today, but I am happy to be here with you today and learn a little more. So the first question is, sorry, how did the model court movement begin, and what was happening at the time that made it necessary? What did those early days feel like?
Well, I guess I can start. What was happening was that juvenile courts all around the country were handling child abuse and neglect cases, and placing kids in foster care while their parents were trying to reunite with them. But then that was it. There was very little more that was going on in courts. As a result, kids were growing up in foster care. They were spending far too many years in foster care, moving often from one family to another. And there were no time limits on when that should end and we should do something else. We should either be able to send them home to their parents or move them into other permanency. And permanency became one of the guiding factors in both the resource guidelines and the model courts. Just so it's clear, the model courts were based upon the original resource guidelines, which were drafted by a committee headed by Judge David Grossman in Cincinnati, and who was also the president at the time, and or was soon to be president. And we knew, all of us generally in the council and elsewhere, we knew that this was happening, that kids were getting lost in foster care, that they were just there and with no real plan for how that would change or how that would end. So we received a grant from the Office of Juvenile Justice and Delinquency Prevention, and we were to put together a publication of guidelines for what resources courts needed to change the way almost all of us were handling child abuse and neglect cases. Some other courts that had indicated an interest in possibly being model courts. One of the first was Chicago. One of the first was Tucson, Arizona, New Orleans, Louisiana, me, Utah, and I think Alexandria, Virginia. I think that was the first group, as well as Cincinnati. So we went about learning what we needed to do in our courts. And one of the first things we had to do was, well, probably the biggest thing we had to do all throughout the process was develop a culture of collaboration with our partners. There were a few courts like Judge Grossman's in Cincinnati, where literally one judge, the presiding judge of the juvenile court, could pretty much tell everyone else what to do. And so that's what happened. And his court moved along that way. But most of us were not in a situation where, one judge could come back from a meeting with the National Council of Juvenile Court Judges and tell everyone, okay, we're changing our system. This is what we're going to do. And this is what you have to do to be part of it. So that was how we got started. I remember vividly coming to Tucson and recognizing that we now had a couple of judges in that court that were really interested in making changes because they knew that their court was not performing well, and the interests of the children were just not being met. Same with most of us. My court became a model court because we actually had to implement the resource guidelines a year before they were released, because our court was facing a federal civil rights lawsuit that challenged the entire child welfare process. And as part of the settlement of that lawsuit, it was determined we really needed to start from scratch and rewrite our entire social services child welfare code and juvenile court code. Unfortunately, the people assigned to do that in the state legislature and their partners knew absolutely nothing about the court process. So I had enough drafts of the guidelines that I took the pile of drafts and went back to the back rooms of the state legislature, and the whole juvenile court part, and therefore much of the rest of it, of our Child Welfare Reform Act in 1994 was based upon the resource guidelines.
Just to follow up with what you've been saying, Sharon, I mean, the system, I mean, I practiced juvenile law for 13 years before I went on the bench. I watched things happen, and thank goodness for the National Council, because our children and families were being terribly abused by the system, and railing as much as I could, still wasn't getting it changed. When I saw and heard judges going forward with an adjudication, with parents having no lawyers, children stuck in foster care forever, nothing happening. Literally, it was a matter of let's kick this can down the road as far as possible. The lawyers were complicit in this as well. Every time there was going to be a hearing, right before the hearing, the lawyer would say, well, our client's almost ready to get their child back, so we want a continuance. They were nowhere near getting their child back. They hadn't done anything, and the lawyer hadn't done anything, and it was just so frustrating. The real big piece was of the resource guidelines and the implementation of the guidelines was that in many jurisdictions, including to some extent our jurisdiction, the hearings were run by the agency. They were not run by the judges. And that's one of the main things that we did at the beginning to make it clear to the judges that these are the judges' cases. We did not have any child welfare people at the courthouse. No child welfare people. The child welfare agency was over here, and they did not engage with the court. They came with their little thing, what they're demanding that we do. And for a long time, it's the old rubber stamp, because a lot of the judges who were at juvenile court, they didn't have any experience in child welfare law. Most of the judges who came to juvenile court, they were just there doing delinquency because they didn't want to do child welfare law, and that wasn't an issue. So they didn't want to deal with it. They didn't want to deal with the hard stuff. So we, changed the culture of the way we do business, and we made sure that we, as judges, convinced people how to do the hard stuff. But the hard part in terms of getting going was that all the judges were skeptical. Some were skeptical at best, and some were just downright hostile. And when we knew we needed some backup. And so we were able to, and the way we got the backup was from NCJ, FCJ. We got Sharon to come. We got other judges to come and do mass trainings for the social workers and for even the psychologists and the other people who we use in terms of trying to get reunification. And so we brought them together to start this collaborative process. But it was, what we got most of the time early on was from the agency is, we can't do this. We can't do it. And I said, well, that's interesting because there are other courts who can do it in these timelines. And Dr. Gatowski over here, and Shirley, they came to court, they came to our court. It doesn't mean that a different judge could be the lead judge of the model court. It could be, quote unquote, a subordinate judge. And that she would have that judge's back. And that judge was me. And making sure that she had my back was a full-time job for her. Because other people were still not trusting it. The agency, we can't do this. Why are you making us do this? We can't file a report. We can't do this timely. We can't have a PPH within 72 hours, which is a lot. And that 72 hours was a long time for a PPH. And we can't do it within 72 hours. And I said, well, if you can't do it in 72 hours, then, maybe we should see if you can do it in 24, like so many of the other judges can successfully do. Maybe you need a little extra caffeine to get it going. And so ultimately, it ended up, I think, being 48, if I remember correctly. And Len Edwards still complained about it being 48, that it was too long. But finally, we got this collaboration going, and things were working out very well. We brought everybody to the table, everybody, police, counselors, everybody you can think of, educators, and we brought everybody to the table. And for multiple years, we had 2 major meetings. So it was an evolution. And there's been a lot of backsliding over time. And I think the advent of the enhanced resource guidelines and the team building of teams going from court to court has made a big difference.
So my experience is like Sharon and Steve's, but I think a couple of differences. Sharon talked about working with the legislature to get things done. For me, I was serving as the chief administrative judge of the court, and one might think that I had the ability just to say, this is what we're going to do, and we were going to do it. But that wasn't the case. And because of the 97 article and a relationship with the Chief Justice of the Supreme Court, the Judicial Administrator of the Supreme Court, I started talking to them about some of the things I was learning from NCJ, FCJ through about the model court, and a desire to use the 97 article as the springboard to do some work in the court, and I wanted the Supreme Court support. And so one of the things I asked the Chief Justice about trying to get done in Orleans Parish was, so at the time there were 6 judges, and all the judges did everything. And like Stephen talked about, many of them didn't want to do, well, some of them didn't want to do any of it, but they were on the bench. They preferred, if they had to do something, they would prefer to do the delinquency work, which I quite never understood. But anyway, they preferred doing the delinquency work. And so one of the things I was able to get the judges to do to agree on creating 2 divisions in the court, a child protection division and a delinquency provision. And we took 2 of the 6 to be in the child protection division and left 4 in the juvenile division. And I agreed, along with one of the other judges, to be the 2 judges in the dependency division. And I also talked to the Supreme Court about the fact that we needed trained lawyers, both for parents and children, and we needed resources, and we needed time to do the work. And so one of the things we were criticized about was having people come to court and wait all day to have their case heard. So the first things we worked on were the getting rid of the cattle call, everybody getting the same time, come to court and wait to 5, right? So we worked on that. The other one was we were seeing a lot of cases being continued. Judge, we just found out we're not ready today. We need a continuance. And so one of the things we did was work on that. And so to work on that, I said every lawyer has to bring their calendar to court. This is a court like any other court. I want the same work ethic that you give for your $1 million client. I want you to bring it here to juvenile court because these cases are just that important. And so don't come in here doing what you would not do if you were representing a client in adult court, criminal court, civil court, wherever. And so they would bring their calendar and I would say, okay, the case is going to be set for what next month on the 15th. And I said, everybody look at your calendar. If your calendar is open at 9:00 and I'm setting this case at 9:00, that means you're going to be here at 9. Don't come on the 15th and tell me you have something in federal court, because the federal court is not taking precedent over my hearing. And so I said to them, when you go to those other courts, just like you come here and tell me, oh, Judge, I have something set on that day, and I go to another day, when you go to that court, you do the same thing, right? So I had a couple of lawyers who didn't quite believe I was serious, and I showed them that I was. So it was working on things like that. And of course, Steve was right. The department said, oh, we can't do that. We can't have a hearing in 30 days. Everybody can't be here. We won't be able to notify people. Yes, we will. And everybody who's here today is getting a notice for the 15th. So we don't have to worry about the sheriff coming to find you. You're getting a notice right now. So those are the kinds of things we did. And every time I went to a model court meeting, I learned something from Steve Rubin, Sharon, or somebody that helped me be able to do something in my court that I think made a difference. And so at some point, my partners kept saying, "Oh, is Judge Gray going out of town? Where is she going? Or she's going to come back with something else for us to do." And while they complained, I think over the years, all of the stakeholders were able to see the benefit of this process and the benefit of the court being involved in the model court project. When they first heard about it, I don't think they were necessarily excited. But by the end of the time, I think everybody would agree that that was an important step in the court's progression to being a better court. Not necessarily yet still the model, but a much better court in terms of addressing the issues that we needed to address.
Yeah, I'd like to just kind of put a pin in this part of the conversation by emphasizing some of the things that you just heard the judges say. At the time of the beginning of the model court movement, courts were under intense pressure. They didn't have the infrastructure or tools to respond thoughtfully to rising numbers of children in foster care who were spending an inordinate amount of times in foster care. So we had, through the National Council, a new blueprint, the resource guidelines, that outlined a process, for courts to implement to improve their case processing of child abuse and neglect cases. We had a committed group of judges who bought into the concept that systems change could be led from the bench, which was a radical concept back in the day. Judicially led collaborative systems change was new. But these committed group of judges bought into it, and they were willing to be those first courts who would step up to pilot those concepts in the resource guidelines, to share what they were learning about their case process with other members of the model courts. We had all of that in place, but the piece that kind of put it all together in a bow and wrapped it up was obtaining funding from the Department of Justice, Office of Juvenile Justice and Delinquency Prevention to give the courts the necessary support in terms of technical assistance and training and cross-site visits to foster that sharing and learning. An annual all-sites meeting. It was that OJJDP model court funding that really launched the model court project in a way that enabled it to be effective. We had, I think, 11 courts originally. You see Judge Rubin, Judge Gray, and Judge McCully here. They were original courts, but those courts were small jurisdictions like Alexandria, Virginia, all the way to the largest urban jurisdictions like Chicago originally. And eventually that grew to even include New York City and Los Angeles. And so it was the seeds planted by these committed group of judges with a well thought out framework or menu for looking at your system and making those changes to hopefully make your system more effective, gathering data, committing to critical reflection and gathering information about how well you were doing and making changes based on that data, having those commitments in place, and then linking you to support for training and technical assistance, not just from the National Council, but from your peers, other courts, not just within the model court, but other courts in the nation, to help you with those systems improvements. I mean, that was really having those pieces in place, I think, at the beginning was what really helped the model court movement to take off. And then seeing some early successes helped counter the skepticism that you've heard the judges, mention that, that we did encounter when the program first launched as well.
Thank you so much. It was so great to hear, directly from you and in your words about how all of this got started and your shifting perspectives from each of you. I'm going to shift this a little bit into more of the legacy part of this, as we're, our 30-year anniversary is upon us. And actually, I don't want to put Dr. Gatowski on the spot, but I think I'd like to hear from you first on this one. Since you have that data lens, I think it'll be a nice setup for the rest of the context of this question. How have model courts changed the child welfare landscape? And what would you say is the legacy of the movement today?
Wow. Well, I would say in so many ways, the model courts have really changed the child welfare landscape. Model courts really transformed, I think, how courts function, helping them to become more child-focused, judicially led, and far more collaborative. From a statistical standpoint, looking back at the research that was done in the model courts, we can see that the model courts reduced the numbers of children in foster care in their jurisdictions. 3 of the largest jurisdictions in the nation, LA, New York City, and Chicago, for example, reduced the number of children in care by 50% since they became model courts. Many increased adoptions and adoption timeliness, like Judge McCully was mentioning, that happened in Utah after focusing on TPR and adoption timeliness. They ensured parents and children had timely and effective representation, as you heard both Judges Rubin and Gray mention. So statistically, we saw the movement of the dial in a positive direction: increased reunification, reduction in time of care. But we also see the model courts pioneering and scaling many of the practices that we now take for granted. We consider some of these practices foundational, but the model courts were the first adopters, and designers of some of these things, like time certain calendaring, like one judge, one family case assignments, front loading of the process, like implementing expanded shelter care, preliminary protective hearings. Child protection mediation was first piloted in model courts, dramatically reducing contested hearings and leading to timelier permanency. Setting hearing quality benchmarks, really focusing on judicial engagement of children and parties who are present in hearings, having substantive discussion of important key issues. All of those were things that were first really focused on and pioneered in, the Model Courts Project. And it didn't just stop at the court level in our model courts. In some places, model courts began with a single judge in a single courtroom, but that didn't last for very long because very quickly the practices there infused across the other courtrooms in their jurisdiction and throughout the state. And then throughout the nation, as other courts outside of this model court bubble were looking at the courts and seeing the positive data and wanting to replicate what they were seeing as effective strategies. So I think that the child welfare landscape has significantly changed because of all of this hard work of these committed courts who weren't models when they started out, for sure, in terms of, you've heard us mention this already, this is the best court ever model, but they were willing to model a process for judicially led collaborative systems change and be open and transparent about all of the things that weren't working and being willing to be innovative, ask the hard questions, and make change.
I can add a couple of things. I think the legacy really is that we recognized that courts, judges needed to own these cases, that judges needed to make sure that they led the way in not just scheduling, but scheduling, expecting people to come to hearings prepared and provide the information that the court needed to make decisions. So I think that's one of the things that really came of it. The National Council had always talked about judges as leaders. This got down to an even more basic level, and that is judges in the courtroom leading the way and enforcing the expectations that that we were going to do this, we were going to do it right, and it would be on us to an extent if we didn't have those permanency hearings at 12 months or less, if we didn't make a decision at those permanency hearings, if we just rolled it over like we used to, and continued it for another review in 6 months or 12 months or 18 months. So I think the judicial commitment to all of these reforms and to actively implement them was really important. As Stephen Ernestine said, I used to come back from model court meetings or other national council trainings and things, and they've told me a few times that they really wanted to throw rocks at me, and this is the other judges, and wish I'd quit going to these meetings, which of course I didn't quit. And we all shared with each other. We used to call it stealing from each other, but we all learned so much from the struggles that other courts were having and how they were approaching those things and what tools we had that might help them, what tools they had that might help us. And if none of us had the tools, then we would figure them out together. We'd figure out, okay, what do we need? Who do we need to fix this one hurdle or this one problem? I think another legacy really was a massive change in federal law. And that was in 1997, the Adoption and Safe Families Act that incorporated many of the requirements, or they made them requirements of the guidelines that we had produced. I have to tell you, even back then, leadership had to come clear from the top, including in Congress, but also the executive branch. Like Sophie said, the Department of Justice really supported us. At the time, Hillary Clinton was the first lady, and she really got behind this. And so her leadership, especially with convening in the legislature, in Congress, was very helpful. And the executive branch obviously had to come along and be willing to take the responsibility of implementing this new law. And it hasn't been easy. And I think that many of our courts are experiencing resistance and change and a little bit of backsliding. So I think one of the things that's real important about model courts is that it really never ends. The leadership and the commitment has to be there. It's not like, okay, I'm done. We do this right. So I think that's really important. And the other thing, and we've talked about child-centered courts, but I never again wanted to look at a child who had been in foster care for 10 years and know that I could have and should have done something better. I should have done something about it. Improving the permanency commitment, I think, is really important. We had to make life better for kids. We had to either return them to their families, which was our first goal in every case, or we had to make sure that they had a permanent legal family, a permanent legal connection to parents, if they couldn't go home. Out of this, the very first adoptions took place in our juvenile court. We had been terminating parental rights, rarely, frankly, because we just didn't do it. We just kept saying, we'll look at it again next year. But even in those cases where the children were going to be adopted, they had to go to another court. One thing I would say is the juvenile court judges who slave in these cases and who are committed to these kids and their families need the reward of either adoption, reunification. We celebrated both because I guess the thing I felt best about after about 5 years was we got length of stay down from well over 24 months to about 11. And so kids weren't in limbo. And we used that word a lot. They weren't in limbo for years. They had somebody that was committed to them, who they knew wasn't going to leave or give them back, who knew who was going to stick with them, and the police weren't going to descend on their homes and take them away or move them. And while obviously there were some that weren't successes, I really felt like those children and their experiences and their best interests were really not just words, not just saying everything has to be in the best interest of the child. They were actions, they were commitments, they were resources. You can't require parents to work really hard for a year if you don't give them the resources to do that either. So that was another thing that really came out of this, especially with front loading. So I think judicial commitment, congressional action, and getting kids out of limbo was the things that I would say were the most important.
I only have a few things to add. I agree with what's already been said. I think I would add just a note to Sharon's, the judges owning the cases. I mean, we've spent a lot of time talking about those two dirty words, reasonable efforts, and the judge's responsibility to make those findings, just like, it's their responsibility to set the cases, to make those findings, hold people accountable to providing the reasonable efforts to reunify or get to permanency in the shortest amount of time possible, making sure we have the services so that parents have a chance at reunification. But when that doesn't work, we cannot let these cases languish. We have to come to permanency at some point, like Sharon said, so that the kids don't languish in foster care. I think the other legacy, so the commitment, judges owning the cases, making the reasonable efforts findings, and I guess the other one is to this idea of collaboration. I think in the process, we learned that judges can't do it alone. Right. That it's not just the court that is a part of this system. There are other stakeholders that need to be at the table, have to be at the table as we go out in the community and talk to the legislature, Congress, or JDP, or whoever about these cases and what families and children need in order to have a fair chance at being reunified. have a fair chance at permanency, to have a fair chance to have one placement only while they're in foster care and not 5 or 15, to have, for the young people who are in the system, to have the opportunity to get a good education. We haven't talked about that, to get a good education. All those things that, as judges, when we're looking at the case, I feel we have a responsibility to ask about. So, is child enrolled in school? How is that happening for the child? What does the child need? What about the health of the child? Medications, all those kinds of things. And so, you're right, for a lot of judges, they said that's too much. That's like social work. I didn't go to law school to be a social worker. I don't want to do that. But we realized as a part of this process that you have to own all of that. If you want to really do what we say we are going to do, look out for the best interests of the children, we have to own all of that. And we can't shy away from it. And unfortunately, there are people who feel like they can't do that, they should be on some of those other dockets. They shouldn't be on this one, because this is hard work. But in the end, I think it's very rewarding. When we see that we have gotten it right and families have been reunified, they're not reunified, kids have had the opportunity to go on to a permanent placement, to be adopted. I can't tell you how rewarding it is to see a young person who was in my court, who's now graduated from law school and is representing children and or parents in the system. And we know those stories are out there, and I take credit for that, right? But we need to make sure children coming along today have the same opportunity as those young people to grow up healthy, happy, in a loving family.
There's so many things that have come out of the resource guidelines, so many innovations wherever they may have began, but so many things that have happened. I mean, Ernestine, you just mentioned the education issue. Our Tucson Model Court started really early efforts to integrate education in every hearing, and we had an educational, an education checklist, a long history of checklists in our work, and the collaboration and case planning and all of those items have generated so much good work. I mean, I remember once going to one of the all sites with my team, and at that particular all site, it was huge. And at that particular all site, they said, well, what is the one thing you're going to do this year? And I remember half jokingly saying, we're going to change everything we do. That's the one thing we're going to do, because we were really committed to just the kinds of things you were talking about, Ernestine, making sure that we're doing it right, and what it takes to be a leader as a judge, to be a leader of these teams that we bring together to our work, and how important it is to have continuity for judges in the child welfare system. And that's a kind of a thing that's bothered me about that. I mean, it used to be in juvenile court, if you were forced to go, your term as a judge would be a year and maybe 2. And we really push hard to make it clear that we're talking about one family, one judge from the start, and you can't have a judge who's only going to be there a year,
right,
to deal with what is the key thing, is that continuity of judge and family in order to hopefully prevent the kind of wasted time or kicking the can down the road that used to occur. And in addition, as the number of judges grew in our court, for example, when I became a judge in the court, there were 2 judges, and today there are 14 in the juvenile division, and most of the time we were dealing with, I think, around 10 judges, 9 or 10, Sophie, I think, when we were redoing the book. So trying to just keep doing it in the right way and checking ourselves, and try to bring on judges who will follow in our footsteps in order to keep this work going. And I'm happy to say that there are a large group of judges right now that are of a generation certainly younger than ours, than mine anyway, that are committed to this work. Just had an opportunity to Sophie and I had an opportunity to be part of a train the trainers for judges who are going to be going, hopefully if there's financial opportunity to do so, to go out and train the people who are the lead judges and the other participants in the model court work. And it was really refreshing to see how that group of judges that we trained really bought into it, and they just did a fantastic job, and they were so ready to go to get out there and bring the word out there. That was very refreshing. So I hope that the council has an opportunity to continue to take this work forward with the new generation.
One thing, if I can just add, that Steve mentioned that I had thought of, is that one of the things we had and continue to have to do is kind of get the whole court system on board so that judges don't spend only 6 months or a year in juvenile court.
Right.
Ernestine and I come from two of maybe 3 at the time anyway, courts that were juvenile courts that were separate freestanding juvenile courts.
Right.
The judges in our courts wanted to be juvenile court judges. They were appointed by the governor to the juvenile court. They were elected in retention elections to the juvenile court. So they really could own these cases because they were going to be the ones making the decisions. They were going to be the ones. It wasn't going to be another judge. That's one reason for individual or direct calendaring, or is so that every hearing wasn't heard by a different judge. That became very important. That, the next hearing you were going to come back to the same judge, and she or he was going to ask you the right questions, or the same questions probably, and the answers needed to be different. So the whole court system sometimes really needed to make changes in encourage and support judges who wanted and were willing to be juvenile court judges and child welfare judges. So yeah, I think that was another thing. I know that there's still a lot of places where judges are appointed for a year or 2 at most, but I think there have been some changes in that regard.
Yeah, I mean, we were able to. I mean, Judge Warner had 5 years.
Yeah,
and
that's
then
right.
And after that, it kind of went sour to the point where we begged and begged and begged, and finally we got an agreement for 3 years. But with that agreement, there still came a situation where what you said, Sharon, about these judges were there for the juvenile court, and that was their goal and their career, and they wanted to be there, which is how I became a judge, is that I was going to be a juvenile court judge for my entire career.
Yeah, so I would agree. I think one of the legacies of the model court movement is a cultural one, because I think that it really changed how courts think about their role and the judge's role, that judges could lead change, not just adjudicate cases. And I think that also served to acknowledge that this is a desirable assignment, being on the child protection bench, because it's a place where you can have real impact and a place where innovation is really possible, and that you can be fully embedded in that. I think that there's still some way to go, but I do think the seeds of elevating the child protection bench were planted in the early model court movement, and then reinforced in the implementation sites, the evolution of the model courts, where we see even more of the principles of the resource guidelines and later document enhanced resource guidelines entrenched.
I think it's really inspiring to be sitting here 30 years later and hearing about this, and seeing my place in all of this as well. And then I'm hoping in 30 years we can look back on the 60 years and really see even more growth and change and evolution, and be proud of all of that work. So I'm looking forward to the next 30 years, as well as very in all of the past 30 years. So thank you so much for all of your work in doing that over the years, and really dedicating yourselves to that. Thank you to our guests for sharing the origins and heart of the model court movement. Join us next time as we explore how model courts began to scale nationwide, celebrating and leading change to bring consistency and compassion to courtrooms.
Thank you for joining us on Court RENOvations. We hope today's conversation sparked new ideas and inspired you to think differently about what's possible in our justice system. Every innovation starts with a conversation, and we're grateful to have you as part of this one. If you enjoyed this episode, don't forget to subscribe and share it with your network. The more we connect, the more we can build a community committed to meaningful, lasting change in juvenile and family courts. To learn more about the work of the NCJFCJ, please visit ncjfcj.org. Please also consider becoming a member if you aren't already, or donating to support our mission. Until next time, I'm Joey Orduña Hastings. Thank you for listening and for being part of our movement to reimagine justice.